A very warm welcome to all of you for this session. Today we will be discussing Right to Information Act 2005, which was also amended in 2019. For a commoner, sometimes there is a question that I am not a law student. Why should I know about Right to Information Act? We are talking about living in the fifth generation of human rights, wherein we are talking about, the clones, we are talking about gaming sites, we are talking about robotics, we are saying that the robots are doing the operations, the robots are taking a lead, but who is behind these robots? The mind is of a human being. So, when we are saying that transparency has to be there as a welfare state, the state has to ensure that the justice is not even done, but everybody should feel that yes, justice has been done within the timeline. So, we are talking about transparency of the government, we are talking about accountability of the government. So, as a commoner, we need to know about Right to Information Act. As I will discuss about the objectives of this act, you will come to know how important this legislation is for the commoners. I will just give you few illustrations before we start about Right to Information Act. If you read the success stories which are available on the website under RTI, you will find that for scholarship people have used RTI, for getting ration card people have used RTI, for getting the road constructed people have used RTI, for releasing out pension, to get the name changed or name corrected in the Aadhaar card, to get the passport on the right time, to see that the ration is distributed to the people for whom the ration is. So, the right people or the entitlement reaches out to the people for which that has been made. So, all this says that if you use RTI, then you will be able to know the status of your pending file. You will be able to know whether you are eligible for any social security, and if yes, then that will be provided to you. For daily routine, if you have a broken road, you approach RTI. For removal of garbage, people have used RTI. So, this is the relevance of RTI. And how can a library use RTI, or how can a commoner use RTI against the library, or to get some information from the library? As a librarian, what is your role and responsibilities under the RTI Act? What do we expect from a librarian? This is what we as a librarian should know, that yes, this is my duty, these are my roles and functions, and this is how I can contribute to the nation at a larger forum. Library is there in every school, in every college, in every university. So, all the librarians can play a very important role in reaching out the social schemes to the commoner, in educating and creating awareness amongst the commoner about Right to Information Act. And if now we discuss the objectives of the session, we will be explaining Right to Information Act. We will also define important terms used in this act, and we will explain the obligations of the public authority. So, by watching this video, you can know the objectives of the RTI Act. You will also understand the definitions used in this RTI Act and the obligations of the public authority. What is the role of the public authority under the Right to Information Act 2005? An act to provide for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities. Time to time the courts have interpreted the term public authorities, and we need to understand that right to information is available for the citizens of India so that they can get information which is under the control of a public authority. So, under the preamble of this legislation, the first objective is to make people aware about different informations which are available with the public authorities. In order to promote transparency and accountability in the working of every public authority, a very important point to understand. And this is why as a librarian you have a greater responsibility, because when we talk about transparency and accountability, how many books have come in the library? How many people have made use of those books? Are the books in public interest, or if there is a content which is against the law, against morality, against decency, are you giving, or are you keeping those books in the library, or you are not keeping books which are contrary to the law, which have some illegal content, which have some content of nudity, which have some content of pornographic material. So, this is where the role of the librarian comes, because when we are talking about transparency and accountability, the catalog is there with the library, the details are there with the library. When when the author or the publisher approaches you to keep your book in the library or to recommend your book for the learners, you have to understand the relevance of that book. If that book is anti-national, or if that book is banned by the government of India, do you think that you will keep that book in the library? Or if that book is having content which is not allowed by different legislations, maybe this is against a particular caste, a particular society or community. So, do you have these kinds of books in the library, or will you keep these kinds of books in the library is a matter of policy. So, any librarian will differentiate between the books which are of public interest and the books which can create hatred, a feeling of divide, a feeling of resentment against the nation, and will not allow those books which are against the law to be placed in the library. The constitution of the Central Information Commission and the State Information Commissions, and for matters connected therewith or incidental to, is the next objective of this legislation, that how will they provide information. So, they will constitute Central Information Commission and State Information Commission, which will ensure that the information reaches to the commoner or the common man. Whereas the Constitution of India has established democratic republic, we are living in a democratic country. We have a republic form of government, that means that the head of the state is not hereditary. So, if we are living in democracy, then we have certain freedoms, freedom to express, freedom to speech, freedom to commute from one place to another, freedom to write, freedom to make statements. But if that writing is against the law, or which is somehow against any community or against any civilization, then that writing should not be made public, and that is not acceptable as per the law. So, we have got freedoms, but the freedoms are not absolute, and this is why we have this Right to Information Act, wherein you can ask for information But what information you can ask and what information you cannot ask is also mentioned in this legislation. So this is not an absolute right that today sitting here, I can ask anything from the public authority. There are certain exceptions which we will discuss and understand. Till you understand the law in total, there is no right which is absolute. So the people who say that rights are absolute, they need to be told that rights and duties are correlated. Every right has an exception to it, so no right is absolute under the Constitution of India or under any legislation which is applicable in India. Whereas democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. A very important concept, We have democracy, so in a democracy, you need to inform the citizens of the programs and policies and about government schemes and the working of the organizations. So there has to be transparency of information. To check corruption, it is very important that the government is accountable and transparent in its functioning. All the government bodies are accountable to the people of India and they should work in a very transparent manner. And whereas revelation of information in actual practice is likely to conflict with other public interest, including efficient operation of the governments, optimum use of limited physical resources and the preservation of confidentiality of sensitive information. A very important point to understand that in the preamble itself, this right has some restrictions. So we have a Right to Information Act which talks about these restrictions in the preamble itself. Anything which is in conflict with public interest will not be disclosed. Anything which affects the integrity or the working of the government will not be disclosed, because the financial resources or the fiscal resources are to be preserved and to be used optimally for the best development of the people of India. So the confidential or sensitive information will not be shared under the RTI Act. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic idea. So the paramount is the feeling that we are all democratic, but the conflicting interest of the people and the government should be handled sensitively on case-to-case basis, and this is where I would like to refer to Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal case, which was decided in 2019. In this, the Constitution Bench reserved judgment, and later on 13th November, the Supreme Court pronounced the judgment. It held that judicial independence does not stand in contradiction with the need for transparency. So the highest court of the country is saying that the judicial independence does not stand in contradiction with the need for transparency. It observed that whether or not information is subject to public disclosure must be decided on the case-to-case basis by weighing competing public interest claims. And they have also given the example. For example, the right to information may have to be weighed against the right to privacy. On the first CIC order pertaining to collegium decision making, it directed its CPIO to re-examine the request, but by taking into account the objections, if any, by third parties as stipulated in section 11(1) of the RTI Act. On the second CIC order pertaining to personal assets of the judges, the court upheld the Delhi High Court judgment and directed the CPIO to disclose the relevant information to Mr. S.C. Agarwal. So this is where the Supreme Court of India says that on case-to-case basis the cases will be decided, and even the judges are not conflicting with the interest of the nation, that is to provide a transparent government. If we talk about the definitions given in the Act, first is appropriate government. Appropriate government means in relation to a public authority which is established, constituted, owned, controlled or substantially financed by funds provided directly or indirectly by the central government or the Union Territory Administration, and the central government by the state government and the state government. So you have to understand that this can be established, constituted, owned, controlled or substantially financed by funds directly or indirectly by the central government or the Union Administration, by the state government in the state. Central Information Commission means the Central Information Commission constituted under subsection 1 of section 12. Central Public Information Officer means the Central Public Information Officer designated under subsection 1 and includes a Central Assistant Public Information Officer designated as such under subsection 2 of section 5. Chief Information Commissioner has been defined under D, and Information Commissioner means the Chief Information Commissioner and Information Commissioner appointed under subsection 3 of section 12. So when we need to understand these definitions, we will have to refer to these sections. Competent authority means the Speaker in the case of the House of the People or the Legislative Assembly of a state or a Union Territory having such assembly, and the Chairman in the case of Council of States or Legislative Council of the state, the Chief Justice of India in the case of Supreme Court, the Chief Justice of the High Court in the case of High Court, the President or Governor as the case may be in the case of other authorities established or constituted by or under the Constitution, the administrator appointed under Article 239 of the Constitution. Information has been defined in F, means any material in any form including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. So the definition of information is very important. When you seek information under the RTI Act, you have to ensure that you are asking information in the following forms. You are asking information about a record, a document, a memo, it can be an email, opinion, advices, press releases, circular, orders, logbooks, contracts, reports, papers, samples, models, data material which are there in electronic form, and any other information which is related to a private body which can be accessed by the public authority under any other law for the time being in force, which is very important to understand. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by the Parliament, by any other law made by the state legislature, by notification issued or order made by the appropriate government. So now you understand the definition of public authority, you understand the definition of information, competent authority, Central Public Information Officer, Chief Informational Commissioner, appropriate government and Central Information Commission. And includes, when we are talking about public authority, it also includes body owned, controlled or substantially financed, non-governmental organizations substantially financed directly or indirectly by funds provided by the appropriate government. Record includes any document, manuscripts and file, any microfilm, any facsimile copy of a document, any reproduction of image or images embodied in such microfilm, whether enlarged or not, and any other material produced by a computer or any other device. A very important definition is of right to information. What do you understand by right to information? Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority and includes the right to inspection of work, documents, records, taking notes, extract or certified copies of documents or records, taking certified samples of material, obtaining information in the form of diskettes, floppies, tapes, video cassettes or in any other electronic mode or through printouts where such information is stored in a computer or in any other device. Now, State Chief Information Commission and State Information Commissioner means the State Chief Information Commissioner and the State Information Commissioner appointed under subsection 3 of section 15. State Public Information Commissioner means the State Public Information Officer designated under subsection 1 and includes a State Assistant Public Information Officer designated as such under subsection 2 of section 5. Right to information is mentioned in section 3. Subject to the provisions of this Act, all citizens shall have the right to information. So, any citizen of India can ask for information subject to the provisions of this Act. So, this right is not absolute but has some exceptions to it. Obligations of public authority is mentioned in section 4. The obligation of a public authority is to maintain all its records duly catalogued and indexed in a manner and the form which facilitates the right to information under this Act. A very important, obligation wherein, every public authority has to maintain the records duly catalogued and indexed in a manner and the form which facilitates the right to information under this Act. So, as a librarian, here comes your roles and responsibilities that you have to ensure that the records are catalogued and indexed. Ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources computerized and connected through a network all over the country on different systems so that access to such record is facilitated. So, at a click of a go, all the records should be made available to the commoner, and this is the use of technology. At a click of a button, we can access all the information which is relevant and which is not against any law. Publish within 120 days from the enactment of this Act the particulars of its organization, functions and duties. So, every organization has this information on the websites, the power and duties of its officers and employees, the procedure followed in the decision making process including channels of supervision and accountability, the norms set by it for the discharge of its function. The rules, regulations, instructions, manuals and records held by it or under its control or used by the employees for discharging its functions. A statement of the categories of documents that are held by it or under its control. The particulars of any arrangement that exists for consultation with or representation by the member of the public in relation to the formulation of its policy and implementation thereof. A statement of the boards, councils, committees and other bodies consisting of 2 or more persons constituted as its part for the purpose of its advice, and as to whether meeting of those boards, council, committees and other bodies are open to the public or the minutes of such meeting are accessible for public, a directory of its officers and employees, the monthly remuneration received by each of its officers and employees, including the system of compensation as provided in its regulation. A very important provision, you know. Sometimes there is a feeling that we are the employees of the government, so we will not part away with these informations, but you know, you have to disclose these information at a place where it is accessible to all. So, how many people are working in this organization? What are their designations, their roles and functions, so that in case as a commoner, if I want to get this information, I know that this department is looked after by this person and this is the contact detail. You need not provide the mobile number of people, but you can give the contact detail, the landline numbers, the email IDs, so that if a commoner has a question or a commoner wants any information, then that person can be approached. So, you know, at one point of time you are saying that you give your mobile numbers, even the personal mobile numbers are there on the websites. On the other point, we see that on some websites the names are also not mentioned. So, there is a contrast which needs to be bridged. So, you should disclose the numbers of the officers and employees of your organization, but you know, if you have a official number, then do share it. If you have a personal number, then you may not share it because of the violation of right to privacy. So, right to privacy is also there, but you have to differentiate between right to privacy and your obligation as an employer or as an employee. So, you have to maintain transparency, you have to have a judgmental level, a reasonable mind, wherein you are providing them the number so that they can contact you in case of need. So, in the library also you have to differentiate between the rights of the people who are working in the library and the rights of the citizens. The budget allocated to each of its agency, indicating the particulars of all plans, proposed expenditures and reports of disbursement made. Very important for library, you know. Every school, every division has a budget. So, if you just tell them, then only they will be able to make the optimum use of that budget. It should not be misutilized and it should not be overspent, so that you have a balance and you can check it. Particulars of recipients of concessions, permits or authorizations granted by it, details in respect of the information available to be or held by it, reduced in an electronic form, The particulars of facilities available to citizens for obtaining information, including the working hours of a library or reading room if maintained for public use. A very important provision, the libraries have become digital, and this is the best use of library because in COVID, in lockdown, we have seen that the open platforms have been used massively by the commoners. Everybody was in the lockdown situation at home, and by these online libraries, by OERs, and we were able to access the content from the home, and we were able to communicate and to enrich our education. So the library plays a very important role in creating legal awareness and also providing education at the doorsteps, because libraries have become digital, so the commoners can access them on their mobile phones sitting at their home. The homemakers, the senior citizens can make use of library and enrich their education. The names, designation and other particulars of the public information officers, such other information as may be prescribed, and thereafter update these publications every year. Updation is very important because many a times people get transferred, people change their designations, their portfolios, so you have to update the information. Publish all relevant facts which, while formulating important policies or announcing the decisions which affect public, provide reasons for its administrative or quasi-judicial decisions to the affected persons. It shall be a constant endeavour of every public authority to take steps in accordance with the requirements of clause B of subsection 1 to provide as much information suo motu to the public at regular intervals through various means of communications including internet, so that the people have minimum resort to the use of this act to obtain information. So if you are having this information on the website, then why will a person use this RTI? So you have to disclose all these informations which are relevant for the commoners. For the purpose of subsection 1, every information shall be disseminated widely and in such form and manner which is easily accessible to the public. All material shall be disseminated taking into consideration the cost effectiveness, local language and the most effective method of communication in that local area, and the information should be easily accessible to the extent possible in electronic format, with the Central Public Information Officer or State Public Information Officer, as the case may be, available free or at such cost of the medium or the print cost price as may be prescribed. So, it is very important that either this information should be free of cost or at a minimum charge. Designation of Public Information Officer is very important. Every public authority shall within 100 days of the enactment of this act designate as many officers as the Central Public Information Officers PIO or State Public Information Officers, as the case may be, in all administrative units or offices under it, as may be necessary to provide information to persons requesting for the information under this act. Without prejudice to the provisions of subsection 1, every public authority shall designate an officer within 100 days of the enactment of this act at each subdivisional level or other sub-district level as a Central Assistant Public Information Officer or a State Assistant Public Information Officer, as the case may be, to receive the applications for the information or appeals under this act for forwarding the same to the Central Public Information Officer or the State Public Information Officer or senior officers specified under subsection 1 of section 19, or the Central Information Commissioner or the State Information Commission, as the case may be. provided that where an application for information or appeal is given to the Central Assistant Public Information Officer or a State Public Assistant Information Officer, as the case may be, a period of 5 days shall be added in computing the period for response specified under subsection 1 of section 7. Very important provision. Many a times, if you have information, then you can just give it. If you do not have the information and the information pertains to a different division, then you should know that you have to forward it to that division. You cannot just sit with that application and after 15 or 20 days say that this is not under my purview. Every Central Public Information Officer or State Public Information Officer, as the case may be, shall deal with requests from persons seeking information and render reasonable assistance to the persons seeking such information. The Central Public Information Officer or the State Public Information Officer, as the case may be, seek the assistance of any other officer as he or she considers it necessary for the proper discharge of his or her duties. Any officers whose assistance has been sought under subsection 1 shall render all assistance to Central Public Information Officer. So, you cannot say that I am not the PIO, so why should I assist you in getting this information? If you have that information and you can assist, then you are duty bound to assist the Central Public Information Officer or State Public Information Officer, as the case may be. By now, we have understood the objective of RTI, we have understood what are the different definitions, very important definitions under the RTI Act. Then we have understood that there is a concept of PIO at center and state level, what kind of information one can ask, a brief format of information, and how can you disclose the information and the designation of public information officers. Hope you have understood the concepts well, and I look forward to have interaction with you in the next session. Thank you all for listening. Have a great day.